Advantages of using ADR. There are many perks of using ADR, rather than going to court. The main ones are for it to be faster, cheaper, more flexible, less stressful, possible to agree on resolutions that are not available in court. The courts can only award damages or one of the fair solutions on this last point. The parties can seek different settlements with ADR. For starters, a debt repayment can be reorganized over a prolonged period of time. And where there is an issue with faulty items, the object may be repaired or replaced. Where the sides are likely to remain to do business in the future, terms for the future can be agreed upon. Advantages of arbitration. The idea that the sides have the luxury of making their own arbitration agreement to work out exactly how formal or informal they want it to offer some benefits. The main advantages are the parties can choose their own arbitrator, so they can decide whether a technical expert or a lawyer or a professional arbitrator will deal with the matter best. If there is a question of quality, it can be determined by a specialist in the particular field, avoiding the expense of obtaining expert witnesses and the time to justify to a court all the technicalities. The time and place of the hearing may be scheduled to match the parties. The actual procedure is versatile, and the participants can choose what is best suited to the situation. This will usually lead to a more casual, more comfortable meeting than in litigation. The issue will be dealt with in secret, and no media will be necessary. The issue shall be resolved more easily than by a court hearing. Arbitration hearings are typically considerably cheaper than court proceedings. The grant is usually binding and is enforceable by the judiciary. Disadvantages of arbitration. There are some drawbacks in arbitration, though, in fact, where the sides are not on an equal footing as to their ability to present their argument. This is because legal aid is not eligible for litigation, and this can hinder a plaintiff in a lawsuit against a business. If the matter had been brought to court, a person with a low income would have qualified for legal aid and thus had the benefit of an advocate to argue his argument. The other big limitations are two. In the case which is not suitable for decision by a non-lawyer arbitrator, an unexpected legal point may arise. Where a skilled arbitrator is working, his payments may be high. This would still be costly because the parties agree for a full trial of testimony from prosecutors and from attorneys on both sides. The appeal powers are limited. In the case of a professional arbitrator and lawyers, the delays for commercial and international arbitration can be almost as great as those in court. This uncertainty and cost issue also ensured that arbitration has, to some degree, lost its reputation as a dispute resolution mechanism for businesses. Many more businesses are looking to the solutions provided by organizations such as the Center for Dispute Resolution by opting to have the issue settled in another jurisdiction in the case of international disputes. One of the issues was that the arbitration law had become complex, and the 1996 Arbitration Act is an attempt to improve the procedure. In fact, it can be said that certain forms of conflict are eligible for arbitration. It covers, in particular, contractual disputes between two companies where the participants have little hope of finding adequate mutual ground to make compromise a realistic prospect, and where there is no substantial point of law involved.